overcome by force, or threats which prevented resistance. Right? So you could have threats which prevented resistance or resistance. What do these threats have to be? What do you think the threat had to be sufficient to overcome the requirement of resistance? Mr. Wonga?
Imminent bodily injury or harm.
Bodily injury, or what
Death.
might also work, even worse,
Death.
death. The threats had to be of serious bodily harm or death. Okay? So what came next? What came next is the law began to shift as legislatures stepped in and the rape reform movement started to have its voice. What came next after the demise or the beginning of the demise of utmost resistance?
I actually have a question
Yeah,
about
sure.
the case. So didn't two prior courts side with the victim? I mean, they charged him with rape,
Right.
or convicted him of rape at trial,
Yeah.
and then he did one appeal, and this is the Supreme Court. So is there any significance in that? Like, I just feel like it was kind of a.
It's a great
weird
question.
outcome.
It would be interesting to have a sort of a history, an account of that trial. What would, but it could be that there's some significance there in terms of why the prosecutors thought that they could win under the utmost resistance standard, why the intermediate appellate court ruled the way it did. But I think however that inquiry, or whatever that inquiry would show, the Supreme Court of Wisconsin's opinion is more representative of the era, more representative of how the standard was applied, and it shows quite starkly why these cases were so hard to win, and why even a prosecutor, prosecutors get a lot of criticism, prosecutors from the almost resistance era, in that they wouldn't bring rape allegations, they even during any sort of inquiry, police and prosecutors would put the victim on trial and dismiss even the prospect of bringing charges. But even a very sympathetic prosecutor would sort of be in a position of holding up almost always his hands and saying, look, this case is not going to result in anything but heartache and not a conviction, and they would not, and so they wouldn't bring it. And I think the Wisconsin Supreme Court's decision sort of would, any prosecutor would say, why should I bring the next case under those circumstances?
Did tort law also kind of follow this or was it really hard to kind of get a civil conviction as well, or like
To get a civil verdict.
damages?
Civil damages. I don't know the answer to that, but I will speculate and take this as speculation because I haven't researched this. I haven't looked for historical articles about the history of trying to use a tort like battery for this. My speculation would be it was no more successful. It was no more promising. It led to, if there were verdicts of that type, they were few and far between. But that would be a great piece of research. Okay, but what came next? What came next?
Reasonable or earnest
Reasonable resistance. The idea was, okay, we're still going to focus on whether there was resistance, but the idea was the problem with this standard was in that it required the prosecution to rule out everything, right? If there was anything that the defense could show or tell the jury she didn't do that could have been resistance, then it couldn't have been utmost. So let's ask for less. Still, we're focusing on resistance, but less. And that leads us to Dorsey. What happened in Dorsey, Ms. Clemens?
So you have a 41-year-old woman who's 5 feet tall, 130 pounds, so pretty petite.
And where was this?
She's in the lobby of her apartment when she gets on.
And this was in New York.
Oh, yeah, New York.
This was in New
1980.
York. So everyone lives in, some people live in walk-ups, but nobody lives in a single-family home, right? It's not suburbia. And so she lives in an apartment building.
Yeah.
And she gets home, and what happens?
So she gets on the elevator off the lobby.
Elevator, you say.
Hey.
So close space.
The word of the day. Will I give the envelope to you? Elevator is the word of the day. She gets in the elevator, and what happens?
So she hits the button for the 10th floor, but before it closes and goes up, there's a young man who gets in, who is 15 years old, so looks like a teenager. He's about my height, 5'7", but he's very large, over about 200 pounds. So she doesn't seem to be paying much attention in the elevator at first, and then she notices him manipulating the elevator buttons, and the elevator stops in between floors. It says the door to the elevator shaft is open, but the alarm bell didn't go off.
So this
they're
is,
trapped.
she's trapped, and every indicator is that this is a deeply threatening situation,
Yes.
right? So what happened?
So he told her to take her clothes off, and she refused, but he repeated that. And then she complied to acts of sexual intercourse and sodomy during the next 10 to 15 minutes. During that time, she didn't scream or anything because she thought no one would hear her.
Now,
Afterwards,
she's still on the elevator, and what happens while she's on the elevator getting dressed?
he did threaten her then,
He
just.
threatened her then, and
He said if anything happened to him the next couple of days, that his friends would get her.
then,
So then he had her get dressed. He got off of the 22nd.
why is that significant?
It's the only express threat that was made during that
No,
time.
I'm not him getting off the 22nd floor. Why is that significant?
Well, she didn't get off at the 10th floor. Like,
She's
she
still
just-
on the elevator
Right,
and he
she's
gets
in the
off on the
elevator, so
22nd
it
floor.
looks like she's still afraid. to do it.
Absolutely. Why is that important?
She's a wealthy woman.
I beg your pardon?
She's a wealthy woman. She lives in a 22, at least, in a 22 floors in New York City.
What does that enable her to do? That she's on the elevator when he gets off on the 22nd floor.
She enables her to get away.
I beg your pardon?
To get away. She can't
Well,
get away.
he leaves, so he gets away, but more important,
To locate where he is.
louder,
To locate where he is, to make
to
sure.
locate where he is, right? He's just narrowed down the search parameters of where she can say he got off the elevator. Makes it very easy for him to be caught, right? And she has the wherewithal to notice he's getting off the 22nd floor, and when she does go to the police, immediately she first reports it to the security of the building development, and they call the police, and he's arrested that night. She identifies him, and he's moving to dismiss the indictment after he's been found guilty of rape. What result, Ms. Clemens, if this case was decided under Brown, under the rule in Brown?
He would have gotten off.
Why?
Because she didn't use the utmost resistance and fight back or scream. She did what he told her.
You could easily, as his lawyer, point to things she did not do, whether it be screaming, whether it be physically hitting him to try to get him to stop. Lots of things you could argue if you were creating his defense that show this fellow's short of utmost resistance. Right? So this is a great illustration of the difference the legal test makes when you apply the facts to it, and how this test would end up leading to his acquittal
or maybe not even being charged in the first place, okay? And even if threats is the standard, threats have to be a serious bodily injury or death to bring about the rape, right? To get her not to resist, to prevent resistance. So you can't say his subsequent threats prevented resistance because they came after his conduct. Okay? So what had been the earlier rule in New York?
If there hadn't been, you couldn't clearly show that there was force and that they physically resisted, you had to show that there were very explicit threats made.
There had to be threats, there had to be forcible compulsion based on the presence of physical force or threats. But so all that language sounds the same. All that language sounds the same. But things have changed in New York. And what's the new test?
So there has to just be earnest resistance.
Earnest or reasonable resistance. Now, the appellate division in a 1975 case called Yannick had put the brakes on any interpretation of the new standard that would differ from the old. The appellate division had said rape is not committed even under the new statute unless the woman opposed the man to the utmost limit of her powers. And that means, since that's the governing rule until and unless it's reversed in another case, we're still at utmost resistance. So now we go to the New York Court of Appeals, which is the highest court in New York again, and what happens?
Well, they do say that there was a definite implied threat, even though there wasn't an
Well,
explicit.
what does the court say about what the right rule should be?
Well, they talk about what should be expected from a woman in a victim's circumstances. So what would reasonably be necessary on her part in that situation?
And so that's, the court says that. And why is that, why did the legislature want to do that? To move away from utmost to reasonable?
So that they don't end up putting themselves at a greater risk of physical injury by resisting. Because I think it talks about the conflict between when police would advise you, don't resist because you're more likely to get injured, but then if you don't resist, then the defendant is much less likely to get convicted.
Then in some circumstances, resistance is more dangerous. That a reasonable person confronted with somebody, a rapist, say, holding a gun, who has already engaged in acts of violence, strangling the victim, or beating the victim, right? If they have done these things, and you say, look, if I resist, he may kill me. Would a reasonable person in those circumstances resist? Continue to physically resist? Well, utmost resistance would say you have to. Reasonable resistance takes into account the circumstances and whether it is reasonable to expect resistance, right? What else might be an explanation other than reasonable fear that would lead a person not to resist? What's another reason that under the circumstances a person might not resist other than fear?
Would you like shock?
Shock, right? There's the freezing reaction. You know, people go into states of catatonia, right? So either fear or shock can lead a person not to resist. These are reasonable reactions, and there's lots of, the legislature had before it a lot of testimony about what people should do and reasonably would do, and how they might often react in ways that make them incapable of resistance.
Maybe presence of a weapon.
Presence of a weapon, right, makes it reasonable to say, I'm not going to resist under these circumstances. I've done anything I can. I said no, maybe before you saw a weapon, before you pulled out a weapon. I said no, I pleaded for my life, and then I saw that this person had a gun, etc. and it was reasonable not to resist as well.
Would location play a factor? Like in this case, the fact that she was trapped between floors on an elevator, would that diminish her capacity to resist?
Being trapped, right, and alone, maybe be more likely to resist if you're in circumstances in which you anticipate or see that there are others there who can come to your aid. Whereas if you're alone and in circumstances where the person has the ability to carry out a threat, you get something else. His name.
The physical advantage of the defender.
Physical attributes. So take all of these things and probably more into account, you can see how different the inquiry is. Right? You can see how different the inquiry is, because for any or all of these reasons, you might say the person didn't do some of the things that if we were just going to make a list, they might have done. And we're going to ask, was that reasonable? Not did they do everything, reasonable or not. Maybe we're going to hold this person to unreasonable expectations. That's what the utmost resistance test does. It says you have to do everything, even if it's not a reasonable demand of you. This says, we'll ask, is it a reasonable expectation? What would a reasonable person have done in those circumstances? Now that test may still be problematic, but you can see how we're moving along this continuum to having a law of rape that is much more favorable to the prosecution. Mr. Wong, did I see your name?
Well, that's exactly the point I was going to make. Depending on our socialization and the makeup of the jury, what's reasonable could look more like utmost resistance, and we're still in that same bubble. So.
Absolutely, there is no perfect solution. But from the point of view of a legal system, right, and the reformers who are urging change, who are in the world of utmost resistance, think about it in, say, 1950, 1960, 1970, as they're trying to think, how do we advance the law? At least get away from this. At least allow juries and their verdicts to be upheld, if they reach them, to be upheld and not struck down based on some standard we're holding a victim to that is completely unreasonable. So that if you're part of that reform movement, you're thinking, this is a big step in the right direction. Now that once we're in that world, it may still seem inadequate, because you can start to see the cracks in the foundation of that body of law. So the fact that it seems, and I think was, a significant step forward, doesn't mean once you're living in that legal world, it becomes sufficient.
Just a procedural question, would the 15-year-old be charged as an adult in something like this?
Ms. Richter, what do you think?
Yes.
And how do you know that?
I would just guess because of the
Adult activity.
yeah.
But how do you know?
fine.
How do you know? I'll answer the question in general, but how do you know? No, how do you know?
Well, in this case, they used his last name.
I'm sorry?
They used his last name, but it was...
In this case, it's in the adult criminal justice system. So they did.
Okay.
They definitely did here. Now, that varies from state to state. What the rules are for trying someone as an adult, more and more states have gone away from allowing certainly juveniles of a certain age to be tried as an adult for any crime, and then sometimes for most crimes. So those rules are in flux. But at this time, it was certainly very common for somebody charged of a very serious crime, once you got well into the teens, 15, 16, that would be the most common thing. That has changed, and it would be much less common today. But he was. I mean, as we've had more and more research into the differences between the brains and development of the brain of juveniles, especially younger juveniles, And when that occurs really in the early 20s, for a lot of people, the criminal justice system has moved towards doing it less and less as a general matter. So our defendant here, Dorsey, might not today be charged as an adult. Wouldn't mean he wouldn't be prosecuted, but it would go through a very different system. Okay? The questions that would have to be answered here, obviously, are whether the defendant exerted physical force capable of overcoming the complainant's reasonable, earnest resistance, or whether the complainant was overcome by fear of immediate death or serious physical injury due to threat from the defendant. That's on 934. What's the answer?
Yes to all of that. So
But there was no express threat until after the intercourse. So where's the threat?
So it says there's an implied threat, an obvious implied threat, because she was trapped in the stalled elevator between floors, no place to retreat to. No matter yelling or not, no one could have possibly helped her.
So you
there's
look
the
at
threat.
all the circumstances that can create an implied threat that would lead a person to say, if I resist, I may be killed, I don't know what will happen, creates a reasonable fear, right? Was it reasonable of her to believe she faced a fear based on a threat, even an implied one, from all of the circumstances? Isolation, physical difference in their sizes, etc. Okay? What about physical force?
It says that his act of manipulating the elevator to make it stop between floors was a physical act that was
And
directed
do you think
at
that's
her.
what the legislature meant by physical force?
No. But
They meant the act of imposing yourself with some physical act of presumably violence on the victim. So what did you think about the court finding manipulating the elevator buttons good enough?
I mean, I personally think yes, absolutely. But it is something that he physically did to make this happen. So I will consider that yes, a physical act.
That's physical act.
Yeah.
And that's one of the things this highlights is how do you go about statutory interpretation, right? If you're going to look to, well, what did the legislature mean by this language, a legislative intent kind of approach, you'd probably say the court is stretching, if not breaking, the rules in interpreting this statute. But if you're going to go with the plain language, the court's saying, hey, this is what the legislature wrote. If they want to change it, they can change it. This was a physical act that brought about the circumstances of this, that created the fear, created a threat, etc. And that's all you need. The legislature wants to narrow it back and make it force actually directed upon the person of the victim. They can do that. In the meantime, we're going to interpret the words. So think about this as an example of how statutory interpretation is done, and you can reach your own conclusions about what you're more comfortable with and how you would go about interpreting a statute in a case like this.
Would it still be the same if the power had cut off instead of him physically pressing the button to stop the elevator?
And then he just, quote unquote, took advantage of the circumstance that he had not created? Well, I think you still have the implied threat part. Whether it would be enough would be hard to say without the physical act. But you would, I don't think you would have the physical act, no. Okay, let me say a couple of quick other things. The book asks whether resistance is even technically required. This is on note 3 on page 935. Whether resistance is even technically required if there is evidence of force or threat, as the New York statute is worded. Under Kentucky law, I want to focus your attention, then we'll talk about it on Wednesday, on 510.010 subsection 2, 510.010 subsection 2, and 510.020 subsection 1, right? Focus on those two subsections and what you think they mean working together for this question of whether resistance is required where there is evidence of force or threat. And we'll talk about that